I have been wondering if delete lols could serve at a McDonald's. We have the response by the defendants to Eunice Lafferty's lawsuit. This is going to be fun. I'll read it for the first time with you. I won't bother with the title, but it's a 12 brackets B brackets 5 motion to dismiss for insufficient process and brief in support. Right, let's get going. Come now, defendants David Holman, Officer Smith, and City of Forney. Hereinafter, Forney defendants. Pursuant to Federal Rule of Civil Procedure 12 brackets B brackets 5, and file their motion to dismiss for insufficient process and brief in support as follows. 1. Introduction. Forney defendants and deficient service. The pro se plaintiff has sued two City of Forney police officers, brackets Officer Holman and Corporal Smith, along with the City of Forney, arising a road rage incident between the plaintiff and another driver occurring November 10, 2021. These Forney defendants have been ensnared in this litigation due to plaintiff disagreeing with the officer's investigation of such accident and the brief detention of plaintiff at the scene. In his complaint, plaintiff decries alleged anti-Muslim sentiment from Officer Holman, although the entire incident was recorded on video, rebuking same. And then we have some footnotes to that first page. Leaving his spurious allegations aside, the plaintiff's threshold problem is more glaring. Neither he nor his internet self-promoting custodian of the court, Jose de Castro, have properly served any of these defendants. The flatedly flawed service of this summons in the civil action is not only evidenced by even a cursory review of the proof of service, docket 8 and 9, but further underscored by the very video posted online crowing about purported but clearly defective service. A copy of such video is attached here too as exhibit number 1. Through the botched handiwork of the plaintiff's cohort custodian of the court, De Castro, the summons was simply dumped with administrative employees in the City of Forney's manager's office and a technician at the Forney Police Department. Specifically, the summons were merely dropped off with Megan Killingsworth, the executive assistant to the Forney City Manager, and Tamara Osborne, a records technician in the police department, neither of whom were authorised to accept federal summons, have it in their job description to do so, nor are they statutorily designated as a proper person for service on a governmental entity. Indisputably, none of these summons were properly served on any individual defendant or a proper representative for the City of Forney, nor did anyone agree to accept service on behalf of any of the defendants. The court should quash the purported service and dismiss without prejudice all claims against these defendants. We'll read this one. The proof of service assigned by Jose de Castro with an address in Santa Monica, California. Presumably, he is the same person on the video. Throughout his video, Mr. De Castro spouts his personal skewed beliefs about the law and freely gives bad advice about filing in the service of a federal lawsuit. He also curiously describes himself as a custodian of the court. And this one, although proof of service form has been doctored to fit Mr. De Castro's curious actions during his service attempt, he marked, under penalty of perjury, that he personally served the individual officers at Forney Police Department and the city at Forney City Hall. Under penalty of perjury, De Castro. And this one, when attempting to serve the officers at the police department, Tamara Osborne can be heard clearly telling Mr. De Castro that the officers are not there. Right, 2. Legal standard. A motion brought pursuant to Rule 12 brackets B brackets 5 seeks dismissal based upon defective service of process. Quinn v. Miller. Under Rule 12(b)(5), defendants may challenge the method of service attempted by the plaintiff or the lack of delivery of the summons and the complaint. Bowman v. Sandolfi Aventis. Once such a motion has been filed, the party serving process has the burden of establishing its validity. Starrett v. Lockheed Martin Corporation. When serving a party fails to meet its burden, a court may exercise its discretion and quash the service and dismiss without prejudice all claims against the improperly served defendants. 3. Arguments and authorities. Plaintiff purports to have served the Forney defendants. However, plaintiff, through putative process server De Castro, just dumped the summons with administrative employees working for the city of Forney. As previously discussed above and described more fully below, plaintiff's service of these summons is wholly insufficient. Federal Rule of Civil Procedure 4 establishes the procedure for effectuating valid service of process. To effect proper service, a summons must be served with a copy of the complaint, Rule 4(c)(1), and the plaintiffs must comply with the rules governing service of process according to the type of defendant plaintiffs seek to serve. See Rule 4(e), delineating rules for serving individuals, Rule 4(h), delineating rules for serving corporations. Additionally, unless service is waived, proofs of service must be made to the court in the form of the server's affidavit, Rule 4(1)(1). Absent proper service of process, a court lacks personal jurisdiction over the defendant, and any default judgment against the defendant would be void. Steele v. Unicorn Group. The federal rules do not permit service by leaving documents at a place of business nor at City Hall. However, Rule 4(e)(1) permits a party to follow state law for serving a summons. Balderas v. Bowell surname. I can never pronounce that. Under the Texas Rules of Civil Procedure, a plaintiff may serve defendants by either delivering to the defendant in person a copy of the citation showing the delivery date and petition, or mailing to the defendants by registered or certified mail return receipt requested a true copy of the citation with a copy of the petition attached thereto. Texas Rules of Civil Procedure. Here, plaintiff's YouTube colluder De Castro did none of this. Instead, he doctored the form, proof of service, to try to contort his actions into valid service upon the Forney defendants, and in the process has now sworn to the court under penalty of perjury that he did so. The sophomoric and theatrical attempts playing to an internet crowd do not constitute proper service under the federal rules or Texas Rules of Civil Procedure. Due to this inadequacy, respectfully, this court lacks personal jurisdiction over these defendants who have not yet been properly served. Accordingly, defendants respectfully request that the court dismiss the plaintiff's claims, or, in the alternative, order the plaintiff to properly and timely effectuate service of process as to each particular defendant. Wherefore, premises considered, defendants David Holman, Officer Smith, and City of Forney pray that the court grant their motion to dismiss for insufficient process, that it dismiss plaintiffs' claims and pleas for damages, and they have such other relief at law or in equity to which it may show themselves entitled. I do look forward to reading the comments on this one.